Hello, my name is Hilary Gershoy, and I am Vice Chair of the Legal Ethics and Malpractice Group at Harris, Wilshire, and Grannis. My practice focuses on helping lawyers and law firms in disciplinary investigations and prosecutions. Today, I will be presenting a CLE on the ethics of honesty, a lawyer's duty of candor both in and out of the courtroom. The agenda for today will be to cover the recent conduct by Rudy Giuliani involving statements made to the court and also statements made to the press. I will go through some of the recent statements that Giuliani has made and filings he has been a part of, and I will go through the applicable ABA model rules, in particular Rule 3.3, Rule 8.4c, and Rule 4.1, which are the rules that deal with a lawyer's duty of candor and honesty. I'll then go through the case law that has analyzed instances in which lawyers have been accused of being dishonest, both in and out of the courtroom. And then I will conclude by providing some tips for compliance and particular lessons we can take from the recent sanctions. So the first part of the presentation is going to go through false or misleading statements to the court. As many of you are probably aware, in June of 2021, the New York Supreme Court Appellate Division suspended Rudy Giuliani from the practice of law for violating the core principles of professional conduct that prohibit a lawyer from being dishonest and making false statements to courts or third parties. This was in the First Department, which is where Giuliani was admitted to the bar. A temporary suspension from the practice of law is quite an extraordinary sanction. It is not typical that a disciplinary panel will decide that pending investigation, a lawyer should be suspended. Usually there is a process by which a lawyer is charged with violations of various rules of professional responsibility. There's an investigation, there's an opportunity to make a showing by the attorney, and then there's a final disposition. So a temporary suspension is not something that we see all that much. In support of its decision to impose a temporary suspension, the court said that Giuliani had made what it refers to as baseless statements that thousands of felons and dead people voted during the 2020 election, and that Georgia voting machines had been manipulated. ABA Model Rule 3.3a prohibits a lawyer from knowingly making a false statement of fact or law to a tribunal or failing to correct a false statement of material fact or law previously made to the tribunal. On its face, that seems pretty straightforward. Don't make a knowingly false statement, and if you realize that you've made a knowingly false statement that is material, you have a duty to correct it. There are some more nuanced aspects of Rule 3.3. And I will note here that when relying on the rules to determine what conduct is prohibited and what conduct is allowed, it's important to look at your local rules. Every state has adopted something like the ABA model rules, but each state has slightly different versions of the rules, and so it's important to consult your state's rules to make sure that you're in compliance. For purposes of this presentation, I'm going to be going through the ABA model rules because most jurisdictions follow some version of what I've outlined here. So regarding Rule 3.3, there is a diligent inquiry requirement, which means that you cannot make a factual statement without a reasonably diligent inquiry to determine if the statement is accurate.